everyone. My name is Peter Zovak, and I would like to officially call this meeting to order of the Landlord Tenant Ad Hoc Committee. Today's a meeting of the regular meeting of the Tenant Landlord Ad Hoc Committee taking place on Wednesday, August 24th, 2022 at 6:10 p.m. Excuse me. May we have the roll call, please?
Jennifer Schultz-Bertelip. Committee Member Razmi Grigorian.
I'm here.
Committee Member Victor Herpetian. Here. Committee Member Tyrell Marchand.
Here.
Committee Member James Son.
Here.
Committee Member Isabella Tevanyan.
Present.
Committee Member David Zargarian.
Here.
Very good. Next item on the agenda is the regular business agenda. May we have the report, please?
The agenda for the August 24th, 2022 regular meeting of the Tenant Landlord Ad Hoc Committee was posted on July 15, 2022 on the bulletin board outside City Hall.
Very good. Moving on, item 3 is approval of minutes. And there are minutes for the June 1st, 2022 meeting, as well as the July 6th special meeting of the Landlord Tenant Ad Hoc Committee. I am aware of at least one comment on the minutes. Are there any other comments with regards to the minutes? Commissioner Gregorian, you did have a comment and a question, correct?
Yes, if I may. Thank you, Mr. Zovak. Under approval of minutes, there are two dates which do not match, and I'm not quite sure which meeting are we talking about. It says minutes of March 23rd, and then motion to approve minutes of April 27th. So that's a discrepancy there. I'm not quite sure what happened there. And overall, I have a question about the quality of the minutes and how they reflect our meetings. But apparently, if you allow me, I will make my comment very briefly now. Otherwise, I will reserve it for item number 6, staff or committee comments.
I would say that if your comment and if your comment and desire on the minutes might prevent you from approving these minutes, then go ahead and bring it up now. We can have the city attorney weigh in on it rather than wait till item 6 on the agenda.
I will really appreciate it. I think that's the appropriate thing to do.
Okay, so go ahead. You can go ahead and bring that item up then.
Thank you. And I would like to hear the city attorney office's comments on this. Generally speaking, minutes are to reflect the meeting that happened. And obviously in a very brief manner, and they don't need to go into details. But when I checked these 2 minutes that were presented to us, July 6th and June 1st, these minutes really do not reflect anything. They don't say anything. There are mistakes in there, and it doesn't show who said what, or it doesn't need to get, again, to details, but at least the highlights of the subject matters that were discussed. Like in business agenda, where it says discussion of possible changes, etc. on item B. Again, it doesn't say what was discussed about, let's say, the subjects that we discussed. So if we put these minutes in front of an interested party, a citizen of Glendale wants to know what's going on in our meeting, I'm not quite sure what these minutes will give them. There is no information, adequate information for the public to know what's going on in here if they don't watch our telecast. So I think we should really improve how we do the minutes. And because of those, even if the corrections are made, I really cannot vote for these minutes because they don't reflect anything. Thank you.
So if the committee recalls, when we first had one of our first or second meeting, we talked about the minutes and the how they'd be prepared. We talked about how they would be action minutes. And I remember explaining that action minutes are very, very brief recaps of what had taken place previously in the meeting. They're not verbatim dictation of what was said by a particular committee member and things like that. Otherwise, they'd be very extensive minutes. And so we did agree that we would limit them to action minutes. And from what I'm hearing from committee member Gregorian is that there's a little bit concerned that the minutes as action minutes presented to you when representing maybe a long meeting and a lot of discussion may not be adequate if someone from the outside were simply to look at those minutes and try and say, well, what did this committee talk about at their last meeting? And it wouldn't really necessarily reflect everything that was said. I don't know if there's something that the city attorney might want to weigh in.
Only that this is consistent with the way council records its minutes. They are action minutes as well. It's consistent with other commissions, boards and commissions. Typically, what you'll see is if there's any more than the action that's recorded, there is a debate that starts up with regard to, I didn't say this, I didn't say that, I also said this. In my opinion, the following sentence was the most important part of what I said, and that does not become an accurate reflection of what happened at the prior meeting, which typically is a month away. Since these meetings are recorded and since these meetings are available online, the best record of the meeting is the videotape itself. And so what the minutes actually do is provide a general description of the agenda items that were in fact discussed, because sometimes we veer away from what the agenda says. We don't get to cover every item. And so someone looking at the minutes would be able to say, oh, we had individuals who spoke at oral comment, or that they in fact did get to item C, 5C on the agenda, and then be able to view the minutes in order to see what occurred. But I do want to ask, with regard to your first comment, you said, it says something about April. I'm looking at the packet, and there's a July 6th and a June 1st meeting. Where did that error occur? If there is that error, we need to fix that now.
I believe the error is item number 3 for June 1st minutes. It says minutes after March 23rd, etc. And then motion to approve minutes from the April 27th. So even the dates don't match in this.
So I'm looking at the minutes of the special meeting June 1st. Item 3 says approval of minutes. That was the agenda item. And at the June 1st meeting, this seems to suggest that we approved the minutes of the April 27th meeting. If you remember, May, we didn't have a meeting. So in June, we would have in fact approved the April minutes.
So what does March 23 do in there?
Lucy, I think that might have been an earlier version we sent out, but the published version has the correct dates on them.
Oh, okay.
I think CPON is correct, and we just very quickly looked online at the minutes that were published, and the wording that committee member Gregorian is contesting is that under approval of minutes, the online version says minutes of the April 27, 2022 meeting.
That's what I was
Committee member
going from.
Gregorian's copy, though, says March 23rd. So it's interesting. I don't know how this gets corrected. It's the committee member's packet appears to be an old version. The posted document is accurate.
The posted document would be the official, the one that we've publicized and shared with the public. That would be the official version. If we've given him an earlier copy that was incorrect, that would just be an incorrect transmittal to him.
So does the committee member then make does any committee member make the motion to say the?
We should hand him now, if we can, what the actual final packet was.
Okay. I will.
I think what we could say as part of the motion is that the committee members received an old version, and yet it was corrected. But insofar as they'd like to make the record crystal clear, we could say that the following correction is being made to make sure that the correct version is in the official records.
Wouldn't it just be easier, since I think isn't the posted one the official?
Yes.
That's the official one. I mean, if essentially the committee members were handed the updated one that was posted, and, you know, obviously.
Your mic.
Oh, I'm sorry. So what I was saying, since the posted one is the official one, wouldn't it just be better for us to just be handed an updated version of what was posted and say, you know, on behalf of the city staff, this is a representation of what was posted. Your email contained in either a former draft or an incorrect draft, and can we move forward on this?
Yes.
I think we're losing a lot of time on this. I appreciate his concern for exactness, but I think that's the simple solution so that we can get going. Otherwise, I'm going to talk a lot tonight.
No, thank you.
Would you like to make a motion to that effect?
Okay, I mean, would you, so I guess the motion would be then at this time is based on the representation of city staff that the posted notice for the public, the general public, indicated the accurate representation of the date of April 27th, and but for the fact that the committee members were simply provided an errant copy, that us being advised that the true copy with the exact date was posted, that whether or not that would satisfy any concerns as it relates to Mr. Gregorian's comments with regards to that specific item that he had concerns about with the minutes. That would be the motion at this time, to accept the minutes as posted.
Second.
May I comment here?
Of course.
Well, okay, we found one mistake, and I trust what you are saying is correct. However, whatever you are saying is about this mistake. How would the commissioners or the public know that there are no other mistakes like that, or other deletions or omissions or whatever else in the minutes?
Well,
If I have to approve something, I cannot rely on the word of somebody that I trust. I need to look at it, and I need to approve it myself. So
do you have a hard copy?
we don't have a copy of that. Neither me nor Commissioner Tevanian have this.
I could supply that to you. If you'd like to push this item to the end of the agenda, we could certainly provide you a copy before the end of the meeting. But with regard to the remainder of the items, the point of approving the minutes is that if you were there, then you would be able to speak to the veracity and the accuracy of the information in the minutes as presented. And if you have other comments, we can certainly fix them at this point. You can also abstain if you don't feel comfortable voting on the motion. You can offer suggestions to make changes. It's up to you.
Yeah, thank you. I'm aware of all of that. Thank you. But I don't want to hold this meeting up for this. I just want to bring this up and make sure that everybody, staff, commissioners, are a lot more careful on these things, and they check accuracy of information that they are given.
Noted, thank you.
So with that, then we stand with the motion by Committee Member Herpetian, second by Committee Member Zagarian. Can we have the roll call, please? Or do we simply go with any abstentions and then move forward?
No, we should do a roll call.
Thank you.
Committee Member Razmik Gregorian,
No.
Committee Member Victor Herpetian,
Yes.
Committee Member Teal Marchand,
Yes.
Committee Member James Son,
Yes.
Committee Member Isabella Tevanian,
Yes.
Committee Member David Zargarian.
Yes.
Very well. Minutes are approved. Next is oral communications. Discussion is limited to items not a part of this agenda. Committee members may question or respond to the speaker, but there will be no debate or decision. Do we have any callers on the line? We do have one caller? Yes, please. We have, and just to note, we have no one in the audience to speak. So one caller, please.
Hello?
Hello,
Hi, can I have your name, please?
Justin Kim.
Thank you, Mr. Kim. You have 2 minutes.
Thank you. Good evening, Glendale Tenants and Landlords Committee. My name is Justin Kim, and I'm contacting you today in hopes you received my email on my tenant living rights and harassment from my landlord. It's been a nightmare to say the least. I live on a property that is designated, permitted as a single-family home where I'm living in a space that was divided up as multi-units. It was built in 2014 when I first moved in. As of recent, I've learned my rights due to harassment from my landlord. She is trying to increase my rent and making eviction threats if I don't agree to her increase. And a non-renewal of lease is critical. I've reached out to the Glendale Tenants Union, and I've been getting support from their amazing team for tenants in crisis. Julia and Teal from GTU have been very supportive and by my side throughout this whole nightmare. Since I've been living here, I've been paying my rent every month on time for 7 years. Even during COVID, I ran dangerously low on funds, but I did not miss one rent payment, nor did I ask the landlord for leniency in rent. All I would like is to come home to peace and tranquility after a 12-hour workday. A landlord should follow all rental laws and not threaten and harass a tenant with eviction if disputed otherwise. Thank you.
Are there any other callers?
No callers.
Very well. Should we just clarify that staff can verify that we are working with this person through the rental rights program? We do know that staff is working with this tenant and is taking a deeper look at the issue and looking at providing assistance where we can. Very good.
Are we able to comment now? Can I make a comment regarding this now, or is that at a different time? Okay, so this is kind of what is happening to Mr. Kim, is what we have discussed before here, where the importance, I believe, of having rental registry. And another thing I think is a workaround what owners are doing is taking their homes, dividing them up, separate leases, separate entrances, and when there's a problem, it's all of a sudden, well, this is a single-family home. But when you rent it, because this kind of happened to me, it was purely a duplex or a triplex. But now when the city's involved, like code enforcement or what have you, this is a single-family home, and this is where it gets muffled. And all of that makes a difference when it comes to, relocation, if that has to happen. When it comes to raising the rents, I think this is a serious issue that we definitely have to address and just know, is this a single-family home? Is it a multi-unit? And also working with the owners to do the right thing. Not putting the onus on the tenant to know you don't have permits. That's not a tenant's responsibility to know if a place has permits or not. So this is what I believe this is a prime example of why we're here, to help navigate this. And another thing is to allow tenants in general to just, like Mr. Kim said, be able to live in peace. And personally, through GTU, I do like to vet tenants if we have issues. So I want to see the receipts. I want to see, what are the text messages? Is she harassing you? Is the landlord or he or she harassing you? Let's see that. Where are they? Are they asking for an increase in rent? Let's see this. I've went over some things with this tenant, and trust me, it's just an embarrassment of what the landlord is putting this tenant through. And this is what I've said to this committee, or mentioned to this committee several times. They are not always calling the city. I always direct them here. But they're starting with GTU, being that these are people who will go out to the house, stand with the tenants in solidarity, give them calm and peace. It should not have to be like this. It should not have to be like this. So this is something that I'm passionate about because I also personally went through it. The difference is I had the wherewithal and the stamina to stand. Most tenants leave, unfortunately. They just don't want the harassment.
Very good. So noted. And I will say that staff will continue to work with the tenant on this. If we do find that in this particular situation, there might be maybe a recommendation for a change to the rental rights program as a result of this exchange. Certainly, we'll look at bringing that back for discussion.
Thank you. And I think too, like we talked about in another meeting, having these type of workshops where, because I just like to see it coming together. Sometimes I do feel the owner does not know. And I'm okay with that, but it's once you know, now, how do we represent ourselves? So we need this change behavior, and it's not fair that a tenant has to go through this, nor is it fair that a landlord goes through it if it's on, the onus is on the tenant. So thank you very much.
Thank you.
Mr. Zola, can I make a comment, please? I do understand all of this, and it is very unfair to the tenant. However, when they contact the city housing department, let's say if there is a subdivision of the house or a dividing of the house to two different units, a single family, doesn't the building department and all the other departments get involved?
Well,
And wouldn't we contact them? I think this is an important issue. The tenant should not be handled the way this gentleman was explaining. That is a complete no-no for me. However, what does the basic question I have is for the public to know. I personally probably know the process. What does the city different departments do to stop this kind of behavior?
If I can just say that this is a matter that we are currently looking into, and so I would just caution us not to get into the details, the specifics of what the caller was calling about. So just allow the staff to work through the process. And then more specifically, we are in the oral comment. This item's not part of the agenda. And so unless you have a specific question with regard to what the caller was talking about, we should probably move on in the agenda to the next item.
My purpose was just a general question for the public to know that the city is not indifferent to this kind of violations, and we have all kinds of departments to go after the violator.
That's correct.
That is correct. Generally, it takes quite a bit of time of communication back and forth with the tenant to get the full and complete story, to get questions that we may have answered. Then it also takes staff time to interact with other divisions, particularly the building and planning, to investigate legalities of units as well, and then how it applies back to the code, and then get back. So it is a involved process that requires a lot of back and forth, both externally and internally.
So this, the case of this gentleman is in an active process.
Of investigation by staff, it is.
Okay, that's all I wanted to make sure that we do.
Correct. Thank you. Okay, and then finally, we move to item 5 is the business agenda. Item 5A is continued review of the rental rights program, chapter 9.30. I know that we did have last month off due to summer break, but it just seems like we were here just the other day. And so we had a very lengthy discussion of the beginning parts of the rental rights program. We're going to continue up again tonight with our continued discussion of where we left off. And depending upon when the committee feels that they've might have deliberated enough, we can go ahead and adjourn the meeting. Any other items that we haven't got to, we can bring back. I know there's a second item on the agenda as well, a discussion of our outreach efforts in the past related to the rental rights program. That's certainly something we have time to bring back at our next meeting if we feel we go along on this discussion. So if there are no questions, I'll go ahead and turn it over to staff, Sipan Zadorian, to continue on and take us where we left off. Maybe remind us where we were and
I think we discussed everything for the just cause eviction, and we were beginning to discuss relocation fees for rent increases over 7%.
okay. And so then you have a PowerPoint to kind of,
No.
or discussion of how to walking us through the,
If you recall, we did have a PowerPoint, but then as we were discussing, the committee preferred going through the ordinance line by line. So we're going to continue going line by line. believe we were past this part. Could you scroll up a little? Keep going. Up, up. All right, I think this is where we left off, or right before this. Lucy. Ready? Alright, so basically what this part discusses is the relocation fee for evictions. We did have a possible amendment, the meeting prior to last meeting. Jessica, if you keep scrolling down. So the current relocation was 2 times fair market rent plus $1,000. We discussed maybe making it 3 times the tenant's monthly rent or the fair market rent, depending on which one's higher, plus $2,000. So that's where we left off. I don't know if you guys want to continue discussion here. So these are the 2 options available right now, or something else the committee has. So current fee is 2 times fair market rent plus $1,000. Once we discussed it, we came up with something like this: 3 times the tenant's rent, or FMR, whichever one's greater, plus $2,000, or something else the committee would like. Any comments?
Well, the only thing I can say is this, is first of all, relocation fees, there's no magic wand to come up with the formula for this. You're dealing with a situation where, number one, there's something already obviously in place that the city council reached a consensus on. So that's helpful, obviously. That's because they lead legislatively. From the standpoint of the relocation fee, I mean, we can make comments, but I also think that ultimately we are simply an advisory committee, and it should also go to them to make a decision based on, since they're the legislatures, they're the ones that were actually voted into office. They have to have a better feel of the public's pulse, because I can tell you my opinion, they can tell you their opinion, but ultimately, I think no matter how proud each of us may be of our opinion, it's really the city council's opinion that matters the most. So if there's ideas, I think you have to give them more than just 1 or 2 options. Because as an advisory committee, that will give them an opportunity or a field to debate what they're most comfortable with. Someone may want to reduce it, someone may want to increase it. And then they'll have to come to a decision based on what they feel is in the interest of the public. FMR, again, at the time, all I can tell you is historically what we looked at. At the time back when we created the Just Cause Ordinance back in the early 2000s, the HUD times 2 plus 1,000 was actually higher given where rents were at that time. And despite saying, hey, give 3 times the rent and all this other stuff, which at the time would have actually come in less than that, nobody was agreeable because the idea was to help the tenant who's genuinely being displaced. So the only comment I would make is, what happens in the future when all of a sudden the FMR goes back down, or the other way, it should flip-flop? The goal here is to establish a mechanism that, and I don't know what that number is right at this point, but for the city council to see this and to project it going forward. So with these items, the relocation to some degree, at least for right now with the city of Glendale, is here to stay. Whether we go with 1 times, 2 times, 10 times, whatever, it has to be a formula that stays in touch with what the conditions are, because you don't want to have to convene a commission or a committee every 5 or 10 years because the rental market's changed. I think this has to be something that there's a consensus and the city says, okay, we're comfortable with that. And I think that it's beyond just our debate. And I think one or two suggestions, I think that's actually not helping the city council. They, again, are the ones that hear from, I haven't heard from a single member of the public yet. And we had our email set up, and I don't think any of us got an email yet. But I'm sure that people are knocking on their doors, and so we should give them some options for them to choose from. I think that the direction would be, is do we use FMR? Do we use something similar to what they incorporated for the more than 7% increases? Do you create a consistency and just go with one so that you don't have this A, B version? You know, the state has its relocation number, which they put in 1946.2. So do you go with that? So I think the city council at some point on this topic needs to kind of chime in, because of the things that we're asked to look at, this is probably one of the important ones. Because ultimately the tenant that gets served with the notice and says you have to be out, if they were getting hypothetically $100,000, chances are they're not going to be knocking on anyone's door, and they're going to say thank you very much and I'll be out on time. But when they're not getting enough, or the formula doesn't feel fair to both sides, that's when this dilemma comes up. So I'm a little bit concerned about, well, this is, you know, what we kind of discussed, and let's do it this way. I think we got to give a variable that also moves with the climate and it moves with the city. Glendale is not Santa Monica, and Glendale is not Burbank. It's not Pasadena. So my comment on this, rather than us back and forth, is do we want to go off of HUD? Do we like using HUD as a reference point? Some will say, you know, back then everyone loved it. But today people are going to be like, come on, HUD, compared to what people are paying for a rental unit, 3 times HUD ain't enough, you know? Do you want to go off of what the tenant's rent is at the time? Is there a variable that tenant's rent times X, whether it's 1 or 10 or whatever? Is that a factor that the people in the city of Glendale can say, yeah, we're cool with that? So do they want to use another reference point? I think once you have that established, then our purpose will be accomplished, which is letting the city council know, put something in place now that you're already thinking this direction that will also grow and move forward, so that we don't have to come back and start this again. Because I'll tell you one thing, if we have another deep recession and the prices go down, you're going to have landlords that are going to be coming in here saying, this is ridiculous. I can't pay a tenant this much money to move. You've got other cities right now that for the last 3 years have not authorized a single rent increase. Yet utility fees have gone up, restaurants have increased their prices, other general goods have gone up, but yet the cities have put a blanket across landlords saying you can't raise rents. So what's going to happen at that point in time? Is a landlord obligated to pay relocation when they're also losing money on the other end with something? So rather than just throw a number, it would be nice, it kind of puts a nice little bow tie on it and ends this discussion. I think that, and I had a discussion with this with a few of the former council members, which is the people that come banging on their door the loudest and create the most problem, had they been given what was an appropriate number, probably would have never shown up, and they would have just gotten up and moved on. I don't think people are looking for confrontations in general. So that would be my 2 cents, because we can sit here and debate 3, 4, 2, whatever. And you'll remember that the discussion on how they even got to subsection B with the rent increase one was a long, drawn-out conversation with mathematics that was way over all of our heads. So if we're going to say, look, these are simple evictions, and we're going to go with 1, 2, 3 times the rent, or 1, 2, 3 times HUD times plus a factor, then let's agree, then have the city council make us an indication to the public that we agree that these are very straightforward relocations, so there shouldn't be a reason for both sides to bicker over relocation. This is token money, and that's how we move on. Or on the flip side, if they think, no, this isn't token money, you're uprooting a family, and you need to be more serious about that, then they also have to approach it that way too.
So just to translate this into a recommendation, and we haven't heard from the other committee members yet, but to translate what you're saying into a possible recommendation, your comment is that there shouldn't be a specific number, but some kind of a formula that moves with the times?
Yeah.
And then I think as staff, what we would appreciate is if you had a specific example from another city that we could look at. We could certainly look at that as well to see if relocation can be tied into some kind of a formula rather than a fixed
Right.
number. I think that would be helpful. And
Well,
then,
if you look at 1946.2, for instance, they look at the existing rent at the time.
right,
That, apparently someone in Sacramento said, that's a great way to use this as a reference. So if the tenant's rent is $2,500 today and it's $10,000 tomorrow, then we know that we're going to use that as the benchmark for all purposes going forward. Now, if people want to use HUD, and it's like, you know,
so then it may be, again, just in the interest of making sure that we're going to type up something, right? Because it has to come back to council in a report.
right.
Would your recommendation, and again, not having heard from everyone yet, would your recommendation be that we look to state relocation formula and suggest that council perhaps consider that as an alternative to what is being currently offered? And I don't remember who made the suggestion from last time for the 3 times. Make that into an alternative, a second mechanism, either increase the existing values or tie it into some other, state, make it reflect what the state does and then allow the council to make the decision.
I think so, yeah.
Maybe we allow the other committee members to comment on this particular item as well.
Yes, I would like to comment. After I hear my colleague over here, I guess you are taking for granted our opinion, and I don't feel the same way. If this ordinance, rental right programs, it comes out to the desk of the city council, it's because we were screaming for that since 2015, as we become 17 GTU, and also other groups that we need to pay attention on that. We were screaming for so many years before it took a place between 2016 and 19. Number 2, we bring to the table to the council member as well the rent freeze. And they listen to us and they hear to us. Maybe it's not something that is very pleasant for them, but with the time and with the persevere in the same path that this have to be touched by them, that's what they go and do. Now you are talking about this item, relocation fee. Yes, I guess we have a decent relocation fee. It's not a formula. We are not going to find a formula exactly, because even though when we present that we want to have a ceiling of 5%, they pass 7%. And right now, 2 other cities, they approve rent control in California with a gap of 4%. So that's what I'm saying. Our opinion counts, and our vote counts too, because we are the one who elect them. And they need to pay. I mean, we're not asking for something out of control either, but we don't want people not to go over this stress when they need to move. It was many, for a long time, people, they were grabbing his stuff and moving out of the place because they didn't have any protections, and we have now. Thank you.
I'm still a little unclear. What is it that you want? I'm trying to.
I said what I said is what we have right now is kind of a decent way to approach relocation fee. And what you say is, our opinion doesn't count because city council, they have their own opinion, that's what it matters. No, sir. That's not what is matters all the time, 100%. Our opinion counts, and it depends how you to approach and for how long, and you bring the facts on the table, and they need to pay attention.
So
Yeah, I think that we were just talking about also just letting legislation, city council does more of the legislative work and understanding the laws. So we're putting that back to them. And I, with our suggestions, with the relocation fee, I personally do like going by what the current rent of a tenant is. And then including that with, because obviously that's what they could afford or technically to pay, so, and then adding on in terms of the relocation fee, what they're currently paying, as well as what, when you do a deposit, so maybe the deposit and then another fee. So it would be, I think, almost what it says here, almost 3 times. So if a person is paying, $1,500 for rent, times 2, for instance. Because I definitely think there needs to be a cushion with what they're paying, then maybe considering some market value as well, along with deposits, for them to be able to relocate. Because obviously when you relocate, you may go into a different rent bracket, not of your choice, but just the way the rent market is.
I just want to make sure I didn't miss it. You said it should be based on actual rent and a multiplier, and then what?
Yeah, I like just including the deposit, like what a person puts down, what is it? The security deposit plus your rent and like another, so pay that twice, the security deposit. So like 3 times. I think that's what we have already here. Yes. So it would be 3 times because we have to consider when a tenant moves, what they're moving to, say like the movers, the extra costs of movers. So it's almost like their rent, the deposit, and another cushion.
So are you saying the rent that they're moving into or the
They're
existing?
currently paying.
Okay, so their actual rent times 3 plus,
I like that, just
3 times the current rent.
because it includes that security deposit if they paid the same amount, for instance, and then that extra cushion.
So would it be 2 times plus the security deposit then, or 3 times plus the security
No.
deposit?
It would be 2 times.
2 times, yeah.
Oh, okay, I
Yeah,
missed
I
it.
can
2 times actual rent plus the
Plus the-
security
plus the
deposit.
security deposit. I can get on board with that because I think the FMR is not only unpredictable, it's not current. And also if we go 3 times or FMR, whichever is more, I mean, the tenant is already if it's less than the FMR, they've already taken advantage of the rent that they paid less than the FMR. It doesn't seem fair that if the FMR is more, the landlord would have to pay more than what the tenant was paying currently. I'd also like to add that when formulating the relocation fee, I would love for the staff and also City Council to take into consideration the units, apartment units that are particularly less than 10 units, more so those that go above that threshold, 6 units, 7, 8 units. The financial hardship for a landlord who has less than 10 units is very different from the financial hardships for a landlord or a real estate company that has 50 units or 100 units. So I would really love for them to take into consideration whether they use a scale effect, whether they're scaling it, or just to take into consideration that the financial impact and hardship is very, very different between a 6 or 7 unit landlord and a 50, 100 unit landlord. My particular experience, and this goes for my parents as well, these are not just investments for these mom and pop landlords. These are also their, for lack of a better word, their pension or their 401k. So that is their retirement. And that is different from a real estate company that owns hundreds or thousands of units where they just use that as an expense. So I really would love to see something where the city is not trying to kind of push out the small mom and pops where they're unable to make a living with their livelihood. If these relocation fees are, higher than what's usually been the case.
Committee Member Sun, if I could ask a clarifying question, please. So what you had just described in terms of what you thought a possible base proposal that would cover, in your thinking, would that cover all units? And then if units are of a higher count, you would see that going up?
Yeah.
Is that what you're saying?
Yeah, just so that, just because the financial hardships with a 100-unit landlord is very different from financial hardship for someone who just owns 6 units. And if we're saying 3 times plus or 2 times plus the deposit plus 2,000 or whatever, that may be just a drop in the bucket for a real estate company versus some real financial hardships for elderly senior citizen who only owns like 6 units.
Mm-hmm.
So I would really love for the council to take consideration of that when they're trying to formulate what a fair relocation fee is.
So are you saying, though, at a minimum, at a minimum, a duplex, a triplex should be at a minimum 2 times actual rent plus?
Well, duplex or triplex would not, they would not
Not a
meet the
duplex, but a
threshold for
triplex.
this relocation fee, correct?
Triplex and a,
So a triplex of it up, the minimum should be 2 times actual rent plus security deposit.
Yeah, I think that's fair.
And then whether or not council would want to consider adjusting it higher as the unit counts of the building get higher.
Right, if we want to use this as a deterrent,
I see.
I think that would be fair.
and then I'm going to ask for a clarification point as well. When we talk about security deposit, that by law they must return. I think what you're suggesting is that in addition to the refund of the security deposit minus cleaning fees, damages, et cetera, the relocation value would be comprised of 2 times actual rent plus whatever the original value of the security deposit was. Keeping in mind that if a tenant moved in, 15 years ago, their security deposit could be only $500, whereas now they're paying a rent in the upwards of $2,000. So then the relocation would be 2 times the actual rent, $4,000, plus that $500 minus, and then in addition, whatever security deposit they would be entitled to. So I think that's the way you were envisioning it, correct?
So you're saying that the calculation is 2 times actual rent plus an amount equal to the amount of the security deposit that's being held.
The security deposit is a state law requirement
Right.
that makes, that the landlord has to return minus any damages.
Right, so it's not saying the security deposit comes back, but an additional amount equal to that tenant's security
Whatever they
deposit.
paid in security deposit.
Equal to the rent amount.
Okay. Then the other point was with regard to small owners. Typically where we've seen a differentiation with a mom and pop situation is up to 4 units, and then 5 units and more are treated differently. They're, from a lending perspective, 5 units and more are treated differently, and anything less than, 4 and fewer are treated differently. Throughout our ordinance, there's a distinction between 5 and more and 4 or less. The other place to consider is when we speak about smaller landlords, do you mean in the aggregate they own no more than, a minimal number, or do you mean that a landlord can own multiple fourplexes, which means they now own, 24 units total, but they are really, so then we're also seeing distinctions between, smaller landlords who occupy one of the units. There's also those types of distinctions. So for our purposes, and again, we're discussing it, it's just important to know specifically what you have in mind so that we can make sure it's reflected in.
I think what I had in mind was the aggregate. I mean, if there's a landlord that owns 10 6-unit buildings. I don't think that was my intention. I think what I was talking about more of in line was a senior citizen couple that just owns like a 6 or 7 unit building and that's it. And then they're kind of, that's their livelihood and pension retirement plan as well. If that same landlord owned 5 or 6 units, or 6 or 7 units, that was not my intention and what I was
Okay.
talking about.
That means will be helpful the rent registry, so we can keep track how many each individual or LLC has owning.
Well, I think for the rent registry, particularly, it should, I feel that it should be optional, and I feel that if a small landlord wants to take advantage of certain incentives to register, because they only have 6 or 7 units, then that should be their incentive to register. But then I also believe that if there are other landlords that don't want to register and not take advantage of certain incentives, they should have the freedom not to register as well.
So the item of rent registry has come up, it's come up at the council level. Council has considered that and rejected the idea. Perhaps what we could do is agendize this at the end. We talked about a meeting where we would have different discussion points from committee members, and then go back to council and say, these are some additional items where the committee felt could use further thought, and see if the council authorizes the committee to continue to discuss these items. I think it's important that we make a note of it so that we could bring it back to
A
you.
quick question on the rent registry that was not approved. Were there any incentives provided for rent registry?
It was just a simple discussion. We never went as far as to bring them our version of a rent registry. We brought them reports on LA County, LA City, other registries in California, but we never went as far as to make recommendations on what we would
Does
have.
LA provide incentives for rent registry, or is just a voluntary?
Don't think it's incentives. I think it's just required, where you just sign up, you pay a fee,
Right.
you're on the registry.
Yeah, I think all the
rent
examples.
registry for City of LA is only for the properties
control.
that are under RSO.
That's
Yeah,
right.
right.
That's right. That's only a rent control thing. That's not everybody report.
Right, but LA has rent control, LA City, county, and that's what we were looking at when we were coming up with the program, to
Well,
a way to enforce it.
but in following up though with the point that was just made earlier, if the city council's already made a decision on that, then unless they give us a specific direction that that's within our purview, I don't think that that's within the scope of what they've asked us to do. And so, for lack of a better term, we don't have jurisdiction over that right now. That's the city council's asked us to go over the just cause ordinance and some of the other tenant outreach items. I also want to go back to the issue that we were just talking about, the security deposit. Back in 2000, when we had our original meeting, I was the one that proposed that relocation even exists in the ordinance. When we had discussions, there was arguments going back and forth between the exemption, and when some of the tenant advocates weren't there, I proposed that relocation be used as a compromise to afford people some relief under unexpected situations. What we're doing right now is exactly what happened back then, and it hasn't worked, which is to use a reference point that the city can have going forward. Security deposits, number one, based on what the 4 reasons are for this termination of tenancy, will usually have to be refunded. So if you're dealing with a governmental order, an illegal tenancy, and you're dealing with an entire demolition of the unit, a landlord may not lawfully deduct that unless you did something above and beyond, like put a giant hole in the floor. They'd have to give that money back. So talking about 2 times rent and then this security deposit, this is going to create a hornet's nest of confusion. The other thing that also that you're doing is there are very crafty ways, both on the landlord and on the tenant side, for me to get rid of any relocation benefits that's due, because there's only a certain look-back period. A new investor that comes into the city of Glendale can just as simply say, I'm going to be doing a lot of renovation, you don't have to pay rent, and guess what? If you go off their current rent, there's no relocation benefits due if they hold it out long enough. So, again, with all due respect, I think we have to do something that can withstand the test of time and can also withstand what goes on in the actual trenches. You're going to have extreme situations where certain tenants are going to take advantage, and you're going to have certain situations where landlords are going to take advantage. But we cannot sit here and plan on the extremes. We'll never finish this discussion. Bring a change of clothes for the next meeting. But what we're dealing with is when we're dealing with a lot of people and they need to be relocated, it's got to be simple, it's got to be understandable, and it has to allow people to move on with their life. Okay, Glendale, back then when we were initiating the payment of the relocation benefits, we simplified the process. A little bit different than what LA had. I like the idea of allowing mom and pops an allowance, but the state law isn't based on what the landlord can afford to pay. It's what they believe is fair for the tenant. What the city of Los Angeles does is they have a provision that says, okay, we are going to require X plus a number. That's the buffer that they afford. And then what they do is they come back and they say, this is the number that we want to apply across the board. And that number has a little excess padded into it, I think. It's my opinion. But then they come back and what they say is, since we agree this is fair across the board, now with the mom and pops, there's the mom and pop exception. So if you qualify, then your rate is essentially, it kind of trims off some of that extra padding. But at the minimum, it provides the tenant a bare minimum that they feel is across the board, this is what will help a family relocate, okay? That's the type of notion that I'm trying to kind of instill because, again, I wish you were present when we had those discussions because the FMR was so much higher and it was like, let's do 3 times. Back then, I think the rents were like $500-600 or something like that. And it was different. So it was like, oh, $1,500, that's not fair. But with the FMR, they were getting like $2,500. It was like an extra $1,000, and everybody was all excited about that. And we were saying, what happens if rents suddenly go up and the FMR stays down because it's a governmental program? You don't know what's going to happen. And sure enough, that's what's happened. Now, do you also take into consideration, you know, if the landlord has larger units, should that be a factor? There should be consideration if the landlord is doing what you had in this example that you said. If you're dealing with a person that's taken a house and divided up into essentially a 5-unit by putting doors all over the place, and I've litigated those cases on behalf of tenants. And rest assured, we've held the landlord accountable that you can't call it a house at that point. That's the other thing too is our recommendations to the city should not circumvent the legal process. All of these remedies already exist in another branch. We cannot be the one silver bullet to solve all the possible problems. So I just want to think forward so that 20 years from now, there isn't another group of people trying to figure out what the best formula is. So.
But I think in general, we just wanted to give some options. So
That's what I'd like to go. And I like
that's all
the
of what we're
idea
saying.
of using the tenant's rent. But again, let me give you an example. New developer comes in. I'm going to tear this place down. It's going to take me 6 months to a year to get city approval. Don't have to pay rent. Or they're going to do certain other things. Or let's say the place is just dilapidated. And then it comes time you give the notice, you don't have to pay any money because you don't have any rent at that point in time. And if you go based on your last 6 months or 12 months average, they can manipulate those numbers. So, and then you've got the FMR argument, which is what is fair, because FMR is clearly lagging behind what Glendale properties are worth, okay? So where is it that the city says, you know what, we're comfortable with fair market rent based on what the tenant is paying, okay? And if that doesn't apply, then FMR, whichever is greater, for instance.
that's what I like.
So
That's a-
there's ways of slicing this onion and peeling it apart, but you got to do it right so that it withstands the test.
Right. So I think, yeah, we're on the same page. I feel it's just, and I like the way you use the word, the excess padding. That's how I'm thinking too, just the excess padding. And again, it's just our suggestions. They ultimately, city council will go through what they feel is right, and again, they legislate, and we'll let them do it. But this is just our opinions, and certain things 20 years down the line, we can't control anyway. So we're always gonna have to come back to the
Just
table.
keep it simple.
Exactly.
Just keep it simple.
Well, I'm all for keeping it
Because
simple.
also with the security deposit, one other thing too. A landlord can technically increase the amount of the security deposit as the rent increases. So what happens for the tenant that started out with a $1,000 security deposit and it could be raised to $2,000 over time? Now you're saying give the tenant back the security deposit. Which number? Is it the 1,000 or is it the 2,000?
Okay, so let me,
The way I heard the discussion was that it would be the current applicable security amount, deposit amount.
The one that's on reserve, you're saying?
It should be the current.
yes.
What's on
So if
reserve?
it was 500 at initial and over time it went up to 1,000, the calculation would then say the $1,000 amount, the current.
Exactly.
But
I think that- I'm sorry.
Please.
I think the idea behind creating this committee was, for the legislature to give us an opportunity, give the public an opportunity to investigate and, provide an intelligent recommendation. Can it be one or two recommendations? Sure, but we should figure out an intelligent recommendation to provide. FMR has been working for quite a number of years. I think we should stick to it, adjust the numbers. The small area FMR, I'm looking online right now, in my zip code, for a one-bedroom is $1,780, for a two-bedroom is $2,270, for a three-bedroom is $2,990. That's about where we are. Are we talking a few $100s here and there? Sure. With taking it into consideration, that, and maybe adding a few $1,000s, should be about where we are. We're, I think, overly complicating it, adding exceptions, 4 units here, 5 units there. It's going to be a mess. If you are a landlord, that means you're a landlord. That means you have responsibilities, whether for 4 units or 10 units. That means you have responsibilities. Nobody forced you to buy anything. If you want to take your money and invest into the stock market, do that. If not, if you're buying a house and you're renting it out to families, then you have a responsibility. End of story.
I agree. And I think that's where we all, at some road, we came to that point, to be honest. And I believe not overcomplicated. But I definitely do agree with, if it is a mom and pop under 4 units, 3 units, just a duplex, there needs to be some wiggle room. I definitely agree with that.
But the thing is, we're only talking like maybe $1,000, maybe $2,000.
I get it.
It's not like we're talking about an arm and a leg and you're gonna buy a car, maybe. It's just a few $1,000s. If you're gonna kick out a family, you can afford a few $1,000s extra.
I get it. I understand.
If I may put my more than 2 cents in here. First of all, there was a comment made that the council should decide on certain things. But one of the reasons the council formed this committee is for us to advise them. So I think whatever we decide and advise them, the council is going to take it very seriously. So we are an advisory committee after all. Having said that, there are several comments that were made in here. We probably need to separate some of the issues that we are discussing overall in here to make it simple and more practical. For instance, we are talking about large units and small units. Then we are talking about what about mom and pop who has 6 units, and what about the very same mom and pop who have 10 buildings of 6 units. All of these are very important issues, but I think we, again, if we want to simplify this whole process, there are some clever, quote-unquote, mom and pops who might own 10 buildings with different LLCs. And so are we going to really go through all of that complication of researching and finding and discovering who owns what and where and all that? Of course we can do that. It's all public records. But that is very time-consuming and burdensome on almost everybody. So to simplify it, I think we could categorize the owners, either individuals or corporations. When there is a corporate owned building, it's a totally different category, especially the ones with, I don't know, 50, 100, 200 units. So, and usually corporate owners are a lot greedier than a normal mom and pop or individuals. That's my experience in the past 35 years that I've been in this business. And in addition to that, maybe LLCs should not be considered corporate, because LLCs are some kind of a mechanism to protect the owners from certain frivolous lawsuits, and I understand that. But the number of units, we probably can limit to just one number, and that's it. But, you know, duplex and quadruplex, and then more than 5 plus, and 12 plus, and then 16 plus, all of these are complicating matters. I'm sure my colleagues remember, and I always am very much for simplification. As far as security deposits come, I think security deposits should be totally out of this relocation fees and costs that we pay if we propose to pay to the tenants. Security deposits are security deposits protected by state law, and they have a certain purpose. If there is a damage, if there is anything, then security deposits are, or if there is a unpaid rent or whatever else the law provides, security deposits are for that. Let's keep that totally out of relocation. And when it comes to relocation, I think I have some kind of a formula. It's not a magic formula, but it has nothing to do with FMR or HUD average or LA County Housing Department, whatever. I think if a tenant, after receiving a rent increase notice, if the tenant decides not to take that increase, if it is more than what the law is allowed, and wants to relocate, obviously that tenant is going to go to another property, which that tenant thinks that is going to be less expensive or lower cost. So why don't we say, okay, Mr. or Mrs. or Miss Tenant, when you find a property of your choice, whatever the rent is, if it is below what I am increasing to, I will pay you 3 months of that rent. And I won't pay you personally, I will pay the landlord, your future landlord, that 3 months. If we do that kind of a thing, yeah, I thank you for your reaction. I note that. However, if we do that thing, then it will be fair to the landlord, and it will be fairer to the tenant, because the tenant will get the 3 months rent that we are proposing here for an actual number. It has nothing to do with an FMR or HU or HUD or anything else that we all agree quite often is outdated and inaccurate. The actual rent that the tenant is going to pay to the new landlord is the actual number. So,
Committee Member Gregorian,
I'm sorry.
I just wanted to clarify something. The relocation you're speaking about is the 7%. We're talking about the eviction relocation. The 7% relocation for increasing it 7%, that doesn't include an FMR. That's a whole different formula. So the one we're discussing right now is eviction relocation.
So the rent increase, I understand what Sipon is saying. The portion, the second half of your argument was reflective of rent increases and what to do for a calculation. We're going to have that discussion later. This discussion right now, the current discussion, is with regards to tenants who are being, whose tenancy is being terminated based on the grounds set forth in the just cause eviction, and what amount of money they should be given. And just to go back, circle back here and some of the notes and what I think I heard. Council is looking for some kind of recommendation from this committee. And this committee was set up.
I'm sorry, please clarify. If a tenant has violated the just cause eviction and being evicted, we are not discussing that we pay them a relocation fee, do we?
No,
No, that's not what we're speaking
this
about.
is the no fault.
I thought that's what you implied.
No, I'm applying to 9.30.035A and the relocation formula for that.
I had a question. I wanted to borrow something from what Ms. Marchand said and what Mr. Zargarian said. We have the possible amendment in the draft that we have in front of us. First, my first question is this: it says relocation fee in the amount of 3 times the greater of tenant's current rent, monthly rent, in effect, or the FMR. It doesn't say the greater of or the lesser of. That's my first question. So I can't tell. Where does that get us, number one? Number two, Ms. Rapetian, I have a question for you. Because ultimately, at the end of the day, you know, with what Mr. Zargarian was saying is we're not splitting hairs over a ton of money. But what is a concern, I will say, is this, is that the Glendale ordinance requires that the payment be made within 5 business days at the time the notice is served, and then within 5 business days that the tenant vacates. If it goes to an eviction and the tenant hasn't vacated, they can use that as an offset and all this other stuff. The City of LA says you create an escrow account or you pay it within 15 days, is how the City of LA works. No matter what happens in these situations, the one thing that I think creates the tentative sensitivity between both sides is A, if the money will be paid, and B, if the person is going to move. Can we legally say that if the tenant receives the money, the entirety of the funds, that the tenant can, that a landlord is entitled to a right to possession after the termination of the notice? That, I know we, as a lawyer speaking, I know that there would be an issue of due process to say that they could not file an answer or that a judgment could immediately be entered or anything like that. But the mechanism that runs into a foul here is when the tenant is required to be given, because in the City of LA, if you pay the tenant the relocation, in my experience, I have seen that the judges will not offset that. So you still have to pay them even if you get a judgment against them and then try to get possession. If there was a way to say, essentially, 30th day, the person's out, and that was the requirement for the landlord to also make sure that all the funds are received, whatever formula is agreed, then you're going to remove this questionable, is the landlord going to play games, is it not enough? Because one of the things that I also see when I represent the landlord side of this, some are actually willing to pay more just for the assurance and the timeliness of the tenant moving. So sometimes this whole problem that we're going back and forth on might be solved between the parties themselves just by the mere fact that there is mutual cooperation. So if there is something in the ordinance to that extent, even if you put a higher dollar number, I honestly think that some landlords, even the corporate ones, would be willing to step up, do whatever needs to be done. I disagree with my colleagues' reference that they're necessarily greedier. I don't like that type of a statement because there's good and bad on both sides. I've seen tenants that are in rent control that are renting out their couches with couch surfing and Airbnb and making a lot more money than the landlord is off that unit. And so if there was some mechanism to expedite this, I don't think there is, but I wanted your opinion.
Yeah, I don't think that there is a mechanism to pay the relocation and then have that translate to a right of possession immediately. There would have to be a legal process, at least through the court, to demonstrate that that had occurred. And I don't see how we can bypass that. You had made a point earlier with regard to the value of the relocation being tied to the state formula. If I understand correctly, I was trying to find what that actual value was, and
It's 1 month's rent.
But then you said that there should be some sort of a multiplier, and you didn't say what the multiplier should be.
I mean, again, we've talked about 3 times rent, 2 times rent. I mean, this is a range that, again, also looking at what Mr. Zargarian, his reference with the current FMRs, they're all in the ballpark. Now, if you want to alleviate any back and forth, you say whichever is greater, you're not going to be that much far off. I don't know if 3 times is quite there. I don't know if 2 or 2.5 times is a more accurate number, given where rents are and how that plays in with the FMR. And then just end the sentence with, or whichever is greater.
And I did note that. I think that was an oversight. The only other thing I would say is that ordinances get reviewed by city council regularly. The commission does not need to reconvene. 5 years from now, it could just be something that the council does on its own and says, just like they did with the section below it, and said we need some sort of a relocation tied into rent increases that are greater than 7%. So that there is a mechanism by which the council can study it. There could be a recommendation from the committee that the council review the values every 5 years, every 10 years. There could be a recommendation, and tying it to the FMR means at the very least that it's sort of keeping up with the times, sometimes a little bit ahead, sometimes a little bit behind, but generally increasing as time moves on. What you're looking for is whether the FMR in this region is so far off from the actual rents in Glendale that it would not be a fair reflection. And it sounds like it's pretty consistent.
Well, you said the
with-
2-bedroom currently was 17 something?
19.
19? I would,
So,
What zip code is that?
that's off. I mean, most 2-bedrooms now in Glendale are somewhere in the 22 to 2,500 range.
Lucy, can I comment on the FMR?
2270
2270?
for 2-bedroom.
What zip code?
91205.
205?
It breaks it down by zip code now? Just
Small
off the-
market.
Off the Long Beach? They're not using off the Long Beach?
Well, now I guess what they're doing,
HUD?
what they're doing is dividing it into small area fair market value,
Yeah.
which is a new multiplier.
Sipon, do you have a comment?
Yeah, if the committee feels like the FMR isn't keeping up, we can do something like this. It's FMR times CPI. So fair market rent multiplied by consumer price index or change in consumer price index. So that would bring the fair market rent up to closer to actual market based on, it's a little complicated, more complicated than maybe you'd like, but that would make it more accurate.
Yeah. And I would add then, the FMRs, it's the way HUD does this, and I think we talked about this earlier when we talked about FMRs. It's kind of like a ship. It takes a couple of years for HUD to adjust one way or another. And so there might be a period of time where you might think it's applicable, and then there's a period of time where it doesn't work for the landlord. There's a period of time it doesn't work for the tenant. The numbers are off. And we've seen that only because we deal with FMRs on other programs over the years. So in this particular case, you have a relocation formula that was established back in 2001. Hasn't changed in 20 years. Has not changed. You're only hoping that the FMR in there is accurate and reflective. And at least at a staff level, we can tell you at half the time, it has not been over the years. And so I heard earlier a committee member say, let's come up with something that doesn't require council action every year to, or let's recommend something that doesn't require council action every year to change. So let's hopefully come up with a formula that will change with the times by the way you recommend it. At a staff level, I think that would be great, to be able to have something that is current every year, or you think is current every year. As a result, this one possible amendment was proposed, and then I heard another one brought forth by committee member Sun. I heard a lot of discussion, but I haven't heard a third possible alternative. And keep in mind, we're not voting on an actual formula tonight. We're coming back at the end of all the discussions on the rental rights program, and then wrapping up. This is where we said this, or this, and then start to take votes at that point in time. The possible amendment that was brought up and highlighted in red on the screen is a relocation fee in the amount of 3 times the greater of the tenant's current monthly rent or in effect, the FMR. I think that particular formula was an attempt to capture what's really the actual rental scenario. Your actual rent or the FMRs, whichever is greater, 3 times, plus $2,000. The other scenario formula I heard, Committee Member Sun, 2 times actual rent plus an amount, not the security deposit itself, an amount equal to the security deposit and the current deposit at hand. I just want to know, are there any other considerations for a possible formula for here that we would want to capture and then bring back?
I like the idea that you mentioned earlier with respect to if we're going to balance these two and to take the current FMR multiplied by the current CPI. I like that. So if you're essentially currently, the current CPI is high, so it's 10%, right? 10 point something, whatever it is. So if you were to take a current FMR, hypothetically, let's just round it out for simplicity, $2,000, you'd get $2,000 plus the CPI, 10%, right? Times 2 plus 2,000. Correct? Yeah, I think that makes sense. That actually, I think that's probably one of the best recommendations I've heard in 20 years of listening to this thing, is to factor in the current CPI, because it's going to float around 4 to 5% usually, sometimes 3s. So it takes a consideration in. I really like that idea. I think you should be up here.
I agree with that as well.
Can I
Thank
repeat
you.
that back? What is the multiplier? Did you say 2 or 3?
On the current rent of the tenant, the tenant's rent, or I like what my colleague was also saying, which is 2 times the rent plus the existing security deposit amount on account, or the FMR, the current FMR, factoring also in addition,
FMR plus CPI.
plus CPI, plus $2,000.
So what I did not hear was a multiplier. So in Committee Member Sun's recommendation, it was 2 times actual rent. I didn't hear you say, is it one times FMR plus CPI? Did you say 2 times FMR plus CPI?
I agree with his indication, which is 2 times the rent plus the security deposit that's on account. That would be the relocation. The existing security deposit that's actually on account gets dispersed under 1950.5. Or the FMR plus CPI plus $2,000,
Does the
whichever is greater.
FMR have a multiplier?
Does
Does the FMR have a multiplier?
Currently, it's what, FMR times 2 plus 2. Yeah, currently our FMR has a times 2. Yeah, this one, for some reason, that was actually, I had forgotten to mention it earlier. The option that we have here actually took a step backwards, because the way it exists right now, it's FMR times 2. Why does this not have FMR times 2 in the amendment, in the proposed amendment? Did someone forget to include that?
No, it's tenant's actual rent or FMR times 3. It was upped.
Relocation, the amount of 3 times the monthly rent in effect.
The 2 is on the...
3 times of the FMR, I see.
So that's what I'm trying to get from you. Are you
I see.
saying, is
I
there a
would say-
multiplier of the FMR? Or are you just saying?
2 times.
2 times.
Keep the existing multiplier that we already have that's in the system.
Okay.
We factor in the CPI, plus you've bumped it from 1,000 to 2,000. And then I also like Ms. Varpetian's indication, which is to have council review this every 5 years, 10 years, whatever, so that it keeps current. And that's a simple formula for people to adhere to.
So
I'm not really sure if this bringing in FMR and CPI would help anything. It will just complicate things for many people, especially for senior citizens and mom and pops, so to speak, because you don't know when that FMR was decided, what date. And since then, if it was 2 or 3 years prior or 1 year prior or something, and how you calculate each annual increase of CPI and all that, I think that just complicates it. We don't need that. It's a good idea, but in this case, I would really oppose it because it just more complication. Again, I keep on insisting I want simplification because a great majority of people do not really want to go into these complications.
I would say that the FMR is historically considered something that is easily identifiable. It's published by HUD on an annual basis. It's something that we then publish. So it is a number that landlords and tenants are able to zero in and identify.
So let's say HUD published their FMR, let's say in June of this year. And there is an issue now that, or in December, that somebody wants to get this relocation or act based on this. How is that FMR and CPI coming into play? How is that calculated practically? I'm talking about practicality.
So I would say you take the FMR, which let's say is $2,000, multiply whatever the current CPI is, say 5%, and you just add that on top of.
But that would, CPI is an annual increase, and CPI and FMR is just an average of whatever you have.
No,
Either
FMR
good.
is annual too. They're both annual. They both have the same
Annual adjustment.
annual adjustments. But if that's a problem, you can always pick a percentage. So take the average of the last 20 years CPI and pick a percentage.
If you take the percentage, then that becomes arbitrary, and it opens the can of worms between a tenant and landlord. We are trying to make it simple so that all these arguments and discussions and misunderstandings will not happen.
Well, I think the goal right now was to figure out how we can make FMR more fluid and flexible throughout the years. And if you just add a percentage to that, if we're saying it's low or it's not keeping up, adding a percentage instead of CPI, if you're saying CPI is complicated to find.
Which means we are going to complicate it.
No, if you just add a percentage, it wouldn't make it that much more complicated. Yes, if it's CPI, maybe it's a little bit more complicated to find that number. We always post it on our website. We'll continue to do it. But if that's complicated, you can always put a percentage if you want to go that route.
What I'd also
I think it's totally unnecessary.
Ms. Varpetian, as far as the ordinance, what I would like to do, though, is with regards to the situation where you're dealing with these illegal housing situations. Every time I've dealt with a client that had an illegal tenancy, the recommendation is pay the relocation, because they're going to call it's a duck. It walks and smells and talks like a duck, so it's a duck. I think we should also add something in the ordinance that says if a landlord, for instance, has a 4-unit or a 5-unit and they've kind of fancied it up a bit, that relocation would be owed to any occupant that's required to move from the premises. It should be clear. I think that will also help deter people that at that point in time, if they want to. If they're going to do it, they're going to do it anyways. But some people may say, if I'm going to turn my single house into a 5-unit, now I have to pay 5 people. I once had a situation, there was 30 people in a single house in Sun Valley, and they paid a significant amount of relocation under the City of LA's guidelines. But I think if we put that in the ordinance, that will also address some of the concerns that we have, which is how do you take away some of these abuses, you know?
That is in the ordinance. So if you have an illegal conversion, and that conversion becomes a triplex, then evicting someone out of a triplex entitles that person who's moving to relocation. That's the way we've interpreted it. That's the way we've regulated it, and we've had cases where that has been the case.
I would
Converting
add,
a single family to a duplex, though, it does fall into duplexes being exempt. So
Right.
that a duplex would not be, but a triplex would be. The point that you're raising and something that we're looking into is what is considered to be a unit, and not just a roommate situation. So that's something that we're also looking into, but it's not something that.
LA has the kitchen requirement, so they look at the kitchen. But what I'm also trying to tell you is just from what I've seen in the past, what also happens is the landlord, let's say, has a house and they split it into a 2-unit. I'm just giving you the basic example, and then they get busted. City shows up. The landlord moves out, or they get their family members to move out. Now they call it a house. And guess what? There's no relocation requirement. So there should be some language that says at the time of discovery, basically, And not so much per room, because I've seen people where they take the walls down, and now they say, it's not a 3-unit, it's a house, because there's no separation anymore. I think what you should look at is potentially adding language as far as how many tenancy agreements are in place, not so much, don't go off the walls, go off it.
Correct. But that's what we look at. You have 3 different households living in 3 different units, and some of them are unpermitted.
Right,
That is considered a triplex,
right.
even though they're built illegally.
But what happens if let's say of the 3 that are there, let's say there's 3 people there, but it's landlord and family, and the third person is really the outside tenant. Then what they do is, I've seen this many times where these 2 will do something, or one person moves, or this person didn't pay the rent, or somehow they get that person out. And then this person, the last person that's left standing, the landlord says, that's a house. That's not a triplex any longer.
So we could look at that section, if you feel like that section does not provide that protection, because that is how we treat it. If you have illegally converted a unit into something that's 3 or more, and then you need to evict them to bring it back up to code, then the tenants being forced to move are considered
Right, but the problem
entitled
is
to relocation.
the smart landlord will wait and not serve a notice until the other 2, we're using a triplex as an example. The smart landlord waits, doesn't serve a notice until the other 2 are resolved. And then they come back, and at the time that they serve the notice to the third one, the rules have all changed, the landscape's different.
If the remaining tenant is in an illegal unit, then then
They're
they're
not an illegal unit because they'll take the walls down. They'll take.
so they're in a legal unit. Why are they're in a legal single-family home at that point?
That they don't want to be in.
Right,
They
but-
rent it as a multi-unit.
Right, but now you've got a single-family home. I'm going to give you a 30-day change of terms, and you're going to now have to pay, instead of your $1,000 a month, you have to pay $4,500 for the house.
Well,
What I'm saying
got
is ultimately, if the notice is coming as a result of the discovery of a multiple unit situation which precipitates a notice from the city, then the landlord at that time essentially has, you take a snapshot, you have 3 agreements or 3 tenancies going on, regardless of what the lay of the land is. So when you screw around with the notices and you try to be smart, ultimately that person has to be treated as though you're giving them a notice on the day that the snapshot is taken.
so yes, the city goes in and finds that you have an unpermitted conversion and you've got 3 units. They're
Yes.
not going to differentiate that you've got to, wait. We're going to hold off on enforcing the requirements for permitting on unit 1, but number 2 and 3, we're pursuing those aggressively.
That's not what also happens. So here's what will happen. You've got 3 illegal units, you're cited, okay? You've got 30 days to comply. Landlord, either, if they're in one of them, will usually move out. The second unit, if it's a family or friend member, it's not a hostile tenant situation, they can do something. They take the walls down, they call the inspector, inspector comes out, look, it's all one space. My tenant's occupying the entire house, that's their place.
But
There's
that's
no
a very-
walls. That gets signed off. I've seen that get signed off all the time.
So then now you've got a tenant who was living in 700 square feet, living in 2,000 square feet.
But it's a single-family house now,
Correct.
right? So then what do?
Increase the rent.
I increase the rent to 5,000.
More than
Tenant can't-
7%.
More than, in a single family, it's not subject to the 7%.
And what
And then
my,
I raise the rent, I'm sorry. I raise the rent, 4,500, 5,000. Tenant, guess what? Can't pay it, they're out the door. No relocation, no nothing. I walked away smelling.
that's my concern is also, I know we're starting with the relocation at a triplex. I don't understand why not as a duplex. And I think like our caller called in, let's say if something's a duplex and we just have a landlord who's already has, for instance, illegal unit. I think anytime there is an illegal unit and you want to evict a tenant because you're mad that they reported, they did this, or whatever the reason, you're just in a bad mood that day, you automatically have to pay a relocation. You're still subject to that. I mean, just kicking people out because that's your mood
The simplification is the snapshot. On the day then that happens, now you could build up 100 walls, take it down, but when the violation is discovered, there should be a snapshot taken at that point, and that's the determining factor. From the tenants that I've represented, this has always been the point, which is immediately we would file an affirmative case so that the landlord doesn't restructure the premises and do something to try to get away from it, because guess what? If you can restructure it, and depending on which city you're in, if you have a $22,000 relocation to pay and you can reconfigure it, it's cheaper to get a couple people to break down a wall than it is to pay relocation.
I lived it. I
So
lived it. So
that's why if you have the snapshot, then the notion would be is, at that point, you've been deemed in violation, you pay whatever the relocation is, regardless
if
of,
it's a triplex or a
or
duplex.
you change it to a house later. Yeah.
Exactly.
Yeah.
I think,
Okay.
yeah.
And in
So
addition,
I captured, I think, what you said, and we will try to incorporate that into the possible amendment. The only other thing that we talked about but didn't collectively address is how many units the landlord owns. I think we were saying that it's in the aggregate less than 6 or 7 units. And for the sake of simplicity, can we make that 4 or fewer? Because again, there's a consistency throughout the code in 4s being handled as personal residences and 5 and above not being considered personal residences.
In totality that they own, or on that parcel?
I think in the aggregate, I think the point was in the aggregate, they own less than he was saying 6 or 7, but I'm wondering if we could have that be consistent with how just the general industry treats 4s versus 5s.
So it's per parcel.
Per parcel.
Yes.
So it's a parcel of 4 or less, it's treated differently than a parcel of 5 or more.
Generally, I think what we've seen is that from a lender's perspective,
Right, it's commercial if you're at 5 or more.
5 and more, and then 4 and less.
But if the same mom and pop have 2 4-unit parcels, under your scenario, how is that, they're both treated how?
I think the recommendation was if the landlord has, in totality, fewer than 6 or 7, not, just anywhere, then it should be treated differently. That landlord should be treated differently. And then the only question I had was whether the 6 or 7 could instead be 4 or fewer.
My comment that I would suggest in that scenario is if it's 4 or less and the landlord occupies one of those units, then I think that should apply. Because once the landlord is on premises, there's a better likelihood that they really need that property to supplement their income. But if they're having multiple, then I don't think that should even be the factor.
Yeah, I think that's a good point, yes.
Committee Member Sun, I didn't hear, though, in the situation where you do have more units, what was the result? What was the accelerator? What did you want to do? Because as I wrote down your suggestion, it's 2 times actual rent plus the amount equal to the security deposit. What is the sliding scale then if it's a larger building? Are you saying it goes up by then times 1.5?
Well, yeah, I mean, if we're using the intent, if the intent is to discourage or deter, right? I guess my point was the deterrence for a smaller unit landlord is much higher than the deterrent for like a real estate company with 100. So I'm saying that deterrence doesn't work when you get up to that 50, 100.
Right. But did you have an idea of what that increase should be?
I don't know, maybe the percentage of the.
And I don't mean to put you on the spot. If not, we could.
Yeah, I mean,
look at
I would think
scenarios.
there would be some kind of formula, whether it's a percentage of the annual rent collected, or I don't know. I mean, that may be a terrible idea, but somewhere where it's not, where it's consistent with what the burden would be for a smaller unit landlord.
Why not keep this the way it is across the board? And if you're dealing with the mom and pop, give them a break off of what we were just talking about. The formula that we have, why don't we use that
Yeah, I
as
actually
the
like that.
across the board? So for instance, right now we have what, the draft version is 3 times the current rent, correct? I mean, 2 times the rent plus the security deposit, correct? And if it's a,
The committee member
I was
signs.
saying 2 times the rent. I said 2 times the rent plus the security deposit, but the actual.
right, the actual,
The
whatever,
actual.
whatever the actual is. But let's say if you're dealing with a mom and pop, then do you want to do 2 times the amount of the rent, but no security deposit, no actual security? So you give them off that, or FMR times 2 plus $1,000 instead of $2,000.
And that's where I went back and asked, is two times rent plus amount of security deposit your base? And did you want to go higher if the project was higher?
I think so.
So I don't know if you're now changing
We
it
go
back.
down.
Yeah,
I think we need to go down.
If I may interject in here, 4 units sounds good and it's consistent with what we have, but I have several friends, clients, and people that I know that they have worked all their lives to have a building of about 8 units, 9 units, 10 units, and they basically rely on this income to substitute their social security income, etc., and live on that. I would think that 4 units is not enough. Probably the better number is between 12 to 15. And the reason I'm making this between 12 and 15 is because above 15 units also need to have a resident manager. And that is another scenario that we might want to consider. But 4 units is definitely for a mom and pop or for a senior citizen who relies on its income is just absolutely not enough. And also one thing I wanted to add in the conversations that we had earlier, I think that if a landlord is in violation of the codes, like dividing a house to 3 units and all that, I think the penalty for that landlord for relocation should be higher, much higher. If a property owner is violating the law, I don't think they should be entitled to the same protection as the law-abiding citizens are. So instead of, let's say, 2 times rent, maybe they should pay 4 times rent for the relocation. I don't know. I'm just throwing a number because I think that will also discourage people to violate the law.
Yeah. I think we can have a discussion, but as the city attorney had reminded us, though, there are other elements of the ordinance that differentiates mom and pop numbers. And so what we don't want to do is now create a whole different set of numbers as well. So I want to.
I agree with that.
But going back to your comment, though, Mr. Zoellick, I think what we should look at, though, is as far as, for consistency's sake, I say we make the formula that we were talking about earlier the one that applies across the board. Because if you just have more units, you're going to have to pay more relocation. I personally don't see why the relocation should be higher because you have more units. If you have more units and you're going to be relocating, you just have to pay more because it's per unit. I think if we're looking for the mom and pop, then what we're doing is we're not penalizing the landlord, but we're also in that situation understanding that there is a uniqueness of what their income situation is with that particular tenancy, and we're giving them a break off of the relocation. That way, and I like the 4 units. I think that that's great. And instead of, like I said, 2 times plus the actual security deposit, you say 2 times the rent and leave it at that, or half the security deposit, or something nominal that it could, because again, going back to Mr. Zargarian's point, ultimately, we are not talking about substantial numbers. But it'll, and again, I think if they have the cooperation of the tenant, if you wanted to really help them, I think the best thing would be is to give them more time, but I don't think that helps the tenant's situation because they want to be out and all that other stuff. By the way, one other thing that I personally like that the city of Los Angeles does as a suggestion is in Glendale, we're giving people their half the rent within 5 business days, and then the other half they get. Chances are if the person is going to relocate, they're going to have to come up with a first and a security because they're not going to get their security until they vacated and the landlord can do an assessment. One of the other things that they allow in LA is the escrow account. You okay?
I'm sorry.
Are you okay?
I'm good. Thank you.
Yeah, but what they also allow for is if the tenant identifies the fact that they have first month's rent and a security deposit that's due with a new landlord, that the landlord is also required, if they opt that way, because they can also give it straight out within 15 days. But if they don't, then the landlord can give the money to the tenant to help them make the deposit on the new location and get moving. So that's just another consideration that I think would help the tenant in this scenario, because they say, great, you gave me half my rent, but, or half the reload, but that's still not enough because I'm moving out of state. And this also doesn't just consider the rent, but also moving truck and, you know, getting the boxes and fuel charges, and some people decide to move out of state, what have you. You know, those expenses can, and all they're required to do is identify it. Most landlords, you know, if they see those types of signs, they're not going to hold back. They're just going to give the money and let the person get moving, because it's helping them both sides. So that's another thing I would consider, making a provision that in the event that the tenant should make a showing, you know, after they've received their money, unless the landlord just decides to pay all of it, that if they should make a showing that they need additional funds, that the landlord should release those funds. Preferably, I know at one point we would ask that people identify who the new landlord is just to verify it, so they don't just, you know, use that as an excuse, but just something else, because waiting 30 days or 60 days is a long time, especially when you got to get going, so.
So again, that's a element of the ordinance that is either in the previous or upcoming section, and something we could, yeah. In the interest of time, we're approaching 8 o'clock. Is there a desire to continue discussion or adjourn to the next meeting?
How many more meetings do we have? More or less. We're about halfway through, I think, no?
Well, technically, we'll have, no, we're not yet halfway through. We also want to, at one point, go to council at a staff level and provide an update, and if there's any additional direction. The discussion about the rent registry is something we'd bring up. And so we could be done in our original timeframe that we anticipated, but I think, actually, I was talking with staff, I think we're about a quarter of the way through, technically. Okay. And about, on the last element of, if I'm not mistaken, on the last element of the rental rights program. So I think we could be on track, considered on track.
Good with me?
Okay, so I do have 3 considerations for a payment of a relocation fee related to 9.30.035A that we will then incorporate back per our discussions. Is there a desire to continue, or do you want to adjourn given 8 o'clock?
I think I would prefer to adjourn. I'm still jet lagged.
Second? Okay. So with that, then we will halt the discussion of the rental rights program here. We'll pick it up again at our next meeting. We will hold over then item 9.5B to the next meeting. And then again, that one's okay, because just to tie it up, we'll talk to you and explain to you what our outreach efforts have been in the past. You'll provide feedback. When we come up and are complete looking at the rental rights program, what we would want to do is go out and get community input on it, with all your alternatives, using the comments that you gave us about additional outreach. And so it just kind of follows that and makes sense. So with that,
So I think we just want to stay on the record that item 5B will be continued to the next
Correct.
meeting. We will also continue the discussion, start the discussion at the next meeting with a continuation of 9.30. Now we're going into number 6.
ad hoc committee members or any staff comments?
I just want to make a comment. You remember about that, the late fee and, the late fee for the rent, that they're waiting for the relief, they're adding.
So, committee member Stefan, you had previously, before the meeting, the question you had asked, and I thought it would be more appropriate if you bring it up during the meeting, was whether or not Is staff aware of when a landlord and a tenant are going through the process of getting the rent reimbursement program through the state of California? Does the state program allow for the charging of late fees for the landlord's reimbursement or not?
We'd have to look at the specifics of that. I wouldn't know that. It's a state program, so.
No?
From what I recall, landlords were not allowed to charge late fees,
Exactly.
but I did review the application and it's changed a few times, so I don't know what it looks like. From what I recall, they did have a section for late fees, but I don't know if it's still consistent because they changed like 3 times. So I'm not 100% sure. We can find out. But then again, it's already closed.
I'm sorry, what late fee are we talking about?
So when there's a non-payment of rent by a tenant, a lot of agreements have a late fee.
That's correct.
So the question came up, if a tenant and landlord have applied through the state's COVID rent relief program, does the state's rent relief program allow late fees to be charged? And if they are charged, whether or not the state program reimburses for that or not?
I can happily answer that question. It is very inconsistent depending on the worker and where it comes from. Some agencies allow late fees and some agencies don't. And I've had that experience several times.
Is it some caseworkers at the state level allow it and some don't?
I'm not quite sure if it's the caseworker or the agency that it's coming from.
Because right now it's all coming from, well, it's being processed by different
You see, there are,
subgroups.
exactly, those subgroups,
Payer is the state of California.
yes, subgroups, depending on the group, some of them allow late fees and some of them don't.
Okay.
I have received both.
That's something we can try and look into, and we can report back at the next meeting then.
Yeah, because it's here
If you
in
like, I'll
families.
be happy to share my experience with you separately and tell you which agency paid me the late fees and which agency didn't.
Very good.
Talking about fees, I've just noticed a new idea that's coming about in the state, vacancy fees. I don't know, obviously it's probably not going to apply to smaller mom and pop shops, but bigger investment groups that want a specific number on that rental, sit on the rental and don't rent it out. So that's maybe an idea. Probably it's outside of the scope of what we're doing now, but maybe an idea that can be considered. I know Oakland's doing it. I know a few other cities are considering it. Just a thought.
What is that again?
Vacancy fee. So it's essentially a fee that the landlord would pay to the city, likely to go towards lower income, subsidizing lower income or buildings or something of that sort. Essentially, just a fee that would go to the city because of vacancies. So if a house is sitting on an investment group is sitting on a house and they're not renting it out.
Oh, if it's not actively being marketed. you're
Correct.
saying. Oh, I see.
We've heard that. We've also heard that there might be a push to limit the amount of money landlords can charge for application fees as well.
Yeah, that just came out as well.
What,
It's a
from
very-
the $35 that they pay for application fee at this moment, or what?
I'm sorry, I didn't hear the
What kind
first.
of fee?
The fee just simply to apply and then do the credit check,
The
coming up with,
$35 sometimes
different
they
landlords
charge.
had different,
Yeah. This is another thing that I was receiving feedback from the tenants, that why they supposed to run their credit for that rent an apartment, but when they are a very good renters, they don't present us as a positive in the credit report as well. So if it doesn't work in one way, it doesn't supposed to be in the other way. You know what I mean? When we apply for the utilities in the city too, they check your credit report. But when you are a very good customer, they don't report it. So it has to be both ways.
all right, no other comments? With that, we go to item 7, new business, which we have none, and then item 8 is adjournment. Make a motion to adjourn.
I move to adjourn.
I second.
And we stand adjourned at 8:05. Thank you.